Welcome back. Okay, so today we're talking about AI, one of my favorite topics, and specifically the legal liability that is quietly building inside your business right now, probably without you realizing it. So, most of the conversation around AI and business focuses on how people are using the tools. There's a lot of talk about creating agents right now and workflows. You might be using ChatGPT or Claude or some other AI platform to draft emails, or maybe you're using an AI writing tool for social media, or even, creating images or videos. And that is all fine, but these conversations miss the bigger picture, and one that we all need to be talking about, because the real risk is in how AI intersects with your revenue model. And IP in general does do that. And it's something I think business owners don't think about enough. But now with AI being such an integrated part of all of our businesses, it's so important for you to understand how that specifically is creating risks. So let's first talk about what I call the copyright problem. The US Copyright Office has been clear, at least to date, that AI generated content, anything, whatever it is that you generate from an AI platform, where the machine is making most of the creative decisions. So you're putting in a prompt, but then it's spitting out a full document or full image, or whatever it is you're asking it to create. If the machine did most of the work, it is not eligible for copyright protection. Even if it was your creative idea and you gave it some instruction and guidance, if the machine did most of the work, it's not yours to own. And in March of this year, March of 2026, the US Supreme Court reinforced this when it declined to hear an appeal from a computer scientist named Stephen Thaler, who sought copyright protection for an artwork generated entirely by his AI system that he was using. The justices left intact the lower court rulings that works without human intervention or human creation are ineligible for copyright. So the Copyright Act requires that there be human authorship. That's literally in the statute. And so that is what the courts are looking for, is proof of human authorship. Now, there have been some cases that have come out where the person putting in the prompt prompted the system 1,000 times or more, like massive number of prompts to refine and adjust, say, a painting or a photograph. And there has been at least one case where the court found that there could be copyright protection, and the Copyright Office did register the work. But that's unusual, and most of us are not spending that much time because AI is a time saver, and so it sort of defeats the purpose if you have to keep prompting it. But what I keep saying is AI is a tool, so I think most people should be thinking of it in terms of like the camera and learning how to be an expert in using that tool. But it has to be your human intervention and your manipulation and use of the tool that overshadows the whatever the the tool is spitting out for you, in order for you to be eligible for copyright. And most of us just don't have that kind of time in the way we're using AI. Now, if you're in a content-based business, like maybe you're an author, a coach, a consultant, maybe you're a media brand, you might be a course creator. And if you're using AI to generate substantial portions of your content without significant human creative input, now that could also mean editing on the back end, okay? If you're not doing a lot of significant editing and revision on the back end, that content may not be copyrightable, which means that anyone could copy it, anyone could republish it, and you would have no legal recourse. It also means you're not going to be able to get copyright registration, which is a prerequisite to being able to bring a case against somebody else for copyright infringement. So if you are in that business, your content is your product. And if it cannot be protected, your competitive moat around your business and for your revenue stream is gone. Now, the Copyright Office has also said, like I said, that if the works using AI tools have sufficient human creative input, they are copyrightable. And so if you are writing a detailed prompt and then substantially editing, rearranging, adding to the output, then you're probably fine. And if you're hitting generate and just publishing what comes out, you're not going to be fine. So if you want protection, and if you consider your content to be your secret sauce, the thing that you don't want your competitors to be able to copy, especially if you have, methodologies, for example, and you're drafting content based on those methodologies. You want to be able to protect that with copyright registration so that nobody can steal it from you. And I promise you, litigation on these issues is prolific. I've represented lots of people in litigation on these issues or in disputes, and there are lots of fights that happen over who came up with what first, and did the original content, belong to the original creator? Was it copyrightable? Was there a registered copyright in place? When did that get registered? All of these things matter. But starting with using AI, you have to be very, very careful that you're not creating liability that could literally give away your creative content and input because you aren't using the AI systems in a way that gives you the ability to protect what you're creating. So that's a really, really big issue. And I advise my clients all the time on how to do this effectively. The next is the branding angle. So AI tools are trained on massive data sets that include existing trademarks, logos, and brand elements, because these AI systems just literally went out and scraped every website on the internet that wasn't behind a paywall. And so it literally has every logo, every trademark, all the branding elements of every business that has a website digested into its learning set. And so the output that an AI system gives you could be substantially similar to an existing protected trademark. And a lot of people say, well, that's not true because the way they feed it into the LLM to train it, it's transformative. This is what a lot of the AI companies are claiming in their court cases right now. But what we're seeing is that a lot of the outputs are almost identical to the inputs. So Disney has brought a massive lawsuit against Midjourney, for example, because Midjourney was spitting out outputs that looked almost identical to original Disney photographs, like stills of Darth Vader or other Star Wars characters or other Disney characters. And so they weren't changed much. It was almost identical, the outputs to what was fed into the system. So what you're getting as an output, you may think it looks original because it's not a famous character, for example, but it might actually be something that belongs to somebody else. So you have to be very, very careful about this, because you could be building a brand identity around an AI generated logo, for example, that looks too much like somebody else's registered trademark. And so you may be setting yourself up for a trademark infringement claim without realizing it. And then there's also the ownership question. So the terms of service for most AI platforms grants you a license to use the output, but the IP rights can be murky. So you need to read those terms of use on their website, because some platforms retain the IP rights in all the outputs. Others do grant broad licenses, but they don't guarantee exclusivity. I mean, how could they? They would never do that because it would open them up to liability. So you could be building your brand around a visual identity that someone else is also using or will use in the future. So the way you own that image, say it's a logo, is you have to own the copyright in the underlying design. Well, I just talked a minute ago about why you might not own the copyright in that design. And so if you don't own the copyright, you really can't own the trademark in it. And so if you want to protect your brand and make sure nobody can copy from you, again, you have to go back to what I talked about with copyright and make sure, if you're using AI to generate your branding and branding elements, you have to intervene and have enough human revision and authorship and creativity in it that it is truly unique and is not going to look like anybody else's work, and it's going to be something that you can own. Okay, so then let's talk about the data problem. If you're using AI tools in your business, think about what the data is that you're feeding into these tools. So many AI platforms use the data that you input to train their models. So if you're putting client information, proprietary business data, that's vital, especially trade secrets or confidential details, either yours or your clients or customers, into an AI tool, you may be inadvertently sharing that information with the AI company and actually helping train their LLM platform, which is basically the brain of the AI platform. So you need to check the terms of service. Most major platforms have options to opt out of training data, but generally you have to pay. So the free levels generally don't let you do that. So you generally have to pay for at least the next level up. and then you have to toggle it off affirmatively. It's not going to be a default. So you have to go into the settings and make sure it's not training on what you're inputting. And then finally, we need to talk about the FTC factor, which is the Federal Trade Commission. So if you are selling products or services that include AI generated deliverables without disclosing that, you may have a deceptive trade practice issue. And I'm sure this is something you probably have not thought about. But the FTC has been increasingly focused on transparency in how businesses represent AI to consumers. And obviously, we're very concerned about things like deepfakes, but this can extend beyond that. This can extend to other things. So if a client hires you, for example, to write their website copy and you generate it with AI and you don't disclose that to your client, or if you're selling designs that are AI generated, say you are a graphic designer, those are regulatory risks if you're not disclosing that you're using AI. So what should you do in these cases? Well, there's two things I can suggest. First, map everywhere AI touches your revenue model, everywhere that you're making money off of the things that you are generating via AI. And I'm not talking about just where your team uses AI tools casually, but where AI generated output actually reaches your customers or clients, your products, your content, your services. That is where the liability could really live. So you need to map that out. And then second, you need to update your terms of service and or client agreements to address AI use, to disclose it. And look, I'll give you a couple more. Let's say third, you should create an internal AI policy, which governs not just your use, but your team members' use of AI within your business, because that's vital to making sure that you have control over how AI is being used and your employees are not accidentally creating liability for the company without realizing it. And then fourth, I would talk to your insurance broker, because most general liability and errors and omissions policies were not written with AI liability in mind. So you need to find out what your insurance covers and make sure that you understand where the limits of your policies are. I would not assume that insurance is going to protect you in these cases. AI is obviously an incredible tool. There are certainly drawbacks, but I use it in my practice every single day. I use it in a very careful way, though, and I disclose that use to my clients in my engagement agreements. But like any tool, AI creates risks when you do not understand how it interacts with and affects your business and your revenue model. So I encourage you to really put some thought into this, get ahead of it, be proactive before it becomes a problem. Now, every business is different and the specifics of your situation really matter. And if anything in today's episode hit close to home for you, I want you to know that I offer a free consultation where we can get on the phone and sit down together and talk about your specific situation and figure out exactly where you stand and what your next steps should be. No pressure, no hard sell, just a real conversation between us about your business and what you need to protect it. So if you're interested in doing that, just go to my website, leveragelegalgroup.com, and you can see on the contact form how to schedule that appointment. And I'll look forward to having that conversation with you. And I'll see you in the next video.